5 powerful defenses to sexual assault allegations. If you've ever been in a complicated relationship or had an intimate moment you thought was mutual, you need to hear this, because in California, it only takes one person's accusation to turn your entire life upside down. No physical evidence, no other witnesses, just one claim, and suddenly, you're under investigation for sexual assault. It can start with a breakup, a fight, a sudden shift in tone. Then you hear, "She said you forced her." A detective wants to ask you a few questions. You think it's a misunderstanding, but behind closed doors, they're already building a case, quietly gathering texts, interviews, timelines, and painting you as the predator. I'm Nana Knight, a former prosecutor and a California State Bar board-certified criminal law specialist and a criminal defense attorney based in San Jose. And today, I'm breaking down 5 powerful defenses that can protect you from sexual assault charges in California when you're wrongly accused, even if you're already under investigation. Let's get started. Defense number 1, actual consent. Let's start with the obvious, but most misunderstood: consent. To get you convicted of sexual assault, the prosecutor must prove there was, number 1, sexual contact, and 2, the alleged victim did not consent. If the alleged victim consented, that is a powerful defense. California law requires consent to be clear, freely given, and present in the moment, not assumed, not implied, and not just because you've been intimate before. But here's where it matters. If there are messages, videos, or witnesses showing mutual interest or agreement, even after the encounter, it can cast real doubt on the accusation. Now let's talk about a real case. A few days after a casual night with someone he'd been seeing, my client started getting strange calls from friends. "She's telling people you assaulted her." He was blindsided, confused. And then came the call from a detective. "We just want to get your side of the story." But here's the thing. My client had saved a text she had sent the morning after, and that text said, "Last night was crazy. Can't believe we did that." That one message, playful, casual, unsolicited, completely contradicted her story. It didn't just raise doubt. It raised serious questions about her credibility. And in a case like this, that's everything. Let's talk about that consent. Let's talk about what consent actually looks like and how the facts can tell a very different story. In many cases, there's no evidence of a struggle, no bruises, no torn clothing, no screaming, no 911 calls, nothing that points to fear, pain, or panic. So the real question becomes, did the alleged victim go along with the advances? And here's a real example. The client and the alleged victim are watching TV. Drinking, laughing. He then turns off the TV. She doesn't say a word. He leans in and kisses her, and she kisses him back. Things escalate. At no point does she resist. No pulling away, no protest, no signs of discomfort. Afterwards, she doesn't run, doesn't leave. She stays hours after and hangs out with him. Not a word about being uncomfortable, not a hint of distress. But then days later, a completely different story. This matters because when there's no force, no fear, and no objection, the prosecution has a serious uphill battle proving that what happened was anything but consensual. So no injuries, no resistance, no outcry. That's not the story of a victim. That's the story of reasonable doubt. Defense number 2, reasonable belief in consent. Not every sexual assault case is about force or violence. Sometimes it's about miscommunication. The accusation sounds like this, "But I didn't say yes." But from your side, "I thought you did." This is where the defense of reasonable belief in consent comes into play, because under California law, it's not just about what the other person felt afterward, it's also about what you honestly believe was happening in the moment, and whether a reasonable person in your shoes would have believed the same. And let me show you what that looks like in a case that almost destroyed someone's life. They met through friends, she laughed at his jokes, sat close, they drank, they flirted, and eventually left together. She said yes to coming over. She didn't resist when he kissed her. She leaned in, took his hand, encouraged it, moved with him to the bedroom, and at no point did she ever say stop or no. No pulling away, no discomfort, just 2 adults acting like they were on the same page. The next morning, no complaint, no panic. She even asked for a ride home. But a few days later, that story completely changed, and my client was accused of sexual assault. Here's what we argued. He didn't force her. He didn't threaten her. And based on everything that happened, the way she acted, the way she responded, he genuinely believed she was saying yes. That belief wasn't a guess. It wasn't based on hope. It was based on her actual behavior of that night, the kind that would have led any reasonable person to think that it was mutual. This defense isn't about excuses. It's about context, because when the signals are mixed, it's not always clear what's in someone's mind. And if you truly reasonably believe that they were consenting, that can make all the difference. Defense number 3, mistaken identity when the wrong person gets blamed. Now imagine this. You're accused of something horrific. You weren't there. You didn't do it. But someone shaken, emotional, and under pressure points the finger at you. Welcome to the terrifying world of mistaken identity. Sexual assault cases are emotionally charged, and trauma can cloud perception, especially in high-stress situations. The truth is, these cases often unfold in chaotic, dimly lit environments. A party, a dark bedroom, a crowded bar, split seconds, blurred vision, panic, alcohol, drugs, shock. So what matters most? The victim's opportunity to observe. Was it dark? How long did they see the person? Were they under the influence? How far away were they? These are the questions that determine the accuracy of an identification, and we break it all down piece by piece. Real case. A college student was accused of groping a woman at a crowded house party. She described him as a tall person wearing a red hoodie and having a beard. But surveillance showed that my client was clean-shaven, wearing a blue shirt, walking into the party after the time of the alleged assault. Even better, 3 alibi witnesses confirmed he was in a different room when it supposedly happened. Her memory was real. Her trauma was real. But she pointed to the wrong person, and that nearly ruined his life. In these cases, it's not just about what the witness felt. It's about what they actually saw. And when we expose the flaws in their identification, the entire case can collapse. Defense number 4, false accusations when the lie becomes the crime. And let me be blunt here, not every accusation is true. And if you're facing one, you're probably asking the same questions my clients do. Why would someone lie about something this serious? The truth? There are many reasons, and none of them will comfort you when the police are knocking on your door. Sometimes it starts with regret, an intimate encounter that felt fine at the time, but later guilt creeps in. They're afraid of judgment. They want to rewrite the story, and suddenly, what was consensual becomes a criminal accusation. Other times, it's manipulation. Like one of my clients, he had a mutual encounter with a woman he had known for weeks. She initiated it, and afterwards, she casually told a friend about what happened. But that friend had an agenda and convinced the alleged victim and told her, well, you didn't actually want that. He took advantage of you, and she panicked. And within hours, she filed a police report. My client was arrested, labeled, humiliated, but we pulled security footage from that night. We showed how willingly she entered his apartment, how she stayed for hours, how she showed zero signs of distress, and she came out laughing from his apartment after the encounter happened. And when the truth came out, the case collapsed. Other false allegations are darker. One woman claimed she was raped by a man after a failed drug deal, but the evidence didn't add up. DNA testing revealed someone else's genetic material. She had lied to get revenge when she didn't get what she wanted. And that lie almost cost an innocent man his freedom. So why do people do this? Sometimes it's to get back at someone. Sometimes it's to gain leverage in a custody battle. And sometimes it's just for attention, for sympathy, or to avoid the wrath of a jealous boyfriend or husband. We've seen it all. Regret disguised as assault, family pressure, mental health issues, ulterior motives like money, custody, or revenge. The saddest part, by the time the truth comes out, the damage is already done. A false accusation can ruin your life, even if it's based on fear, pressure, or pure spite. But when we uncover the truth through text, surveillance, timelines, and inconsistencies, the whole story starts to unravel. And once their lie starts falling apart, so does their case. Defense number 5, challenging the pretext call. When silence is your strongest defense, it usually starts with a surprise. Your phone rings and it's the last person you expect, the alleged victim, or their parent, emotional, confrontational. They say things like, "Why did you do that to me? You know what happened. Just be honest. Tell the truth. And in that moment, your instinct is to keep the peace. I'm sorry you feel that way. I didn't mean to upset you. Can we just talk? What you don't realize is the police are listening in. They're recording every word because that conversation, it's not just a phone call. It's called a pretext call, a law enforcement tool that's designed to make you talk, to get you to confess, to get you to admit to the sexual assault. And you don't have to admit to a crime. You don't even have to mention what happened. Even a vague apology can be twisted into a confession. Real example. In one case, a young man received a call from the alleged victim's father. The father was livid, demanding answers. Caught off guard and trying to de-escalate, the young man said, "I didn't mean for anyone to get hurt. I'm sorry." That single sentence, said out of fear and confusion, was introduced in court as proof of guilt. But a closer look told a different story. The words were ambiguous. There was no confession. He had no idea the conversation was being monitored by law enforcement. The defense argued that the statement was misinterpreted, taken out of context, and based on the mistaken belief that the call was about a completely unrelated incident. That challenge was enough to raise doubt, and the case didn't go any further. So what's the strategy here? If you ever get a call like this from someone accusing you wrongly of sexual assault, confronting you, or trying to clear the air, hang up immediately. Say nothing. Call a lawyer, because the truth is, talking can convict you. Silence can save you. A pretext call isn't about the truth. It's about bait. But when we challenge the call's meaning, expose the setup, and dismantle the narrative, their gotcha moment can fall apart. And that can be the beginning of your defense. And there you have it, 5 powerful defenses that can turn the tide in a sexual assault case. Consent, when the evidence shows the encounter was mutual and voluntary. Reasonable belief in consent, when you honestly believed it was consensual based on the other person's actions. Mistaken identity, when the accuser got the wrong person and you can prove it. False accusation, when the allegation is driven by revenge, regret, pressure, bias, or some sort of a manipulation. Challenging the pretext call, when your own words are twisted and silence could have saved you. Just because you've been accused doesn't mean you're guilty. But if you wait too long or say the wrong thing, you can make the situation worse. Let's be clear, a sexual assault charge isn't just a legal problem, it's a life crisis. You could face years in prison, lifetime sex offender registration, you can lose your career, your kids, your reputation, your family, even your freedom. But if you move fast and smart, you can fight back. The fight isn't on the phone. It's not in your text messages. The real fight is in court with the right defense strategy and a lawyer who knows how to dismantle the case against you. If you or someone you love is being investigated or has already been charged with sexual assault in San Jose or the surrounding areas, call my office now for a confidential case review.